everyone. Good afternoon again for this fourth lecture on the Chicago and FGV Forum in Law and Economics. This is a joint initiative developed by the University of Chicago Law School, FGV DIREITO Rio, and FGV DIREITO São Paulo, an initiative that we intend to develop for the coming years, for the next years, presentially in Rio and in São Paulo. I would like, first of all, to thank again my colleagues, Maria Lúcia from FGV DIREITO São Paulo and Professor Omri Ben Sahar from Chicago University for making this project possible. Before we start, I would like to remind you all that all the statements made by our professors and guests represent their own opinion and not necessarily the institutional position of FGV. We also all here agree that this broadcast will be recorded for future use in the video channels of FGV and Chicago University. For today's lecture, I would like also to remind you that it is possible to send your comments and questions through a link in the YouTube chat from Slido. So please feel free to do so. I'm very happy to introduce you and to give the word to a friend of mine, my colleague, Professor Tomás Pereira, who is a full-time professor of constitutional law in FGV DIREITO Rio. And also, we are very pleased to have today again, Professor Adam Chilton from the Chicago University Law School, who also will participate in the end with comments and questions. I think there will be a very rich afternoon again. So thanks again, Professor Tomás, for being here with us, and you have the microphone to go on and give your speech. Thank you very much for coming.
Oh, thank you very much, Rodrigo. I'm going to just, and we can start. Here you go. So, hello, it's a pleasure to talk to all of you about constitutionalism, constitutional courts, and constitutional rights in such an excellent forum. And I thank the organizers for the invitation. I'm sure this is only the beginning of a very fruitful conversation. So in our previous class, in your previous meeting, discussing do constitutional rights matter, Professor Chilton addressed, drawing on his work with Professor Versteeg, he discussed a relevant question for the field, a general question. Thus, putting a right in a constitution cause governments to actually respect it in practice. Well, as Professor Chilton says himself, his answers still leave open the possibility that there are other conditions that might matter. And his book and his work is not the end of the debate on the role that constitutions can play in the protection of human rights. So following this invitation to a conversation, I'm going to focus today in four related but different questions, right? So what can constitutions do to begin with? When can constitutions do this? How can constitutions do this? And what do constitutional rights have to do with any of this, okay? So my presentation is going to be divided in three parts. The first one, I'm going to talk about constitutionalisms, and I'm going to ask, is there a relationship between the political origin of a constitutional law and the way constitutions can matter? In the second part, I will be discussing constitutional courts and constitutional governance. So what I'll be asking is, why are constitutional courts created and how can they matter? Finally, on the third part, I'll be discussing the relationship between constitutional rights and constitutional design. And I'll be drawing on a study of some of the Brazilian case studies. And I'm going to discuss specifically the constitutional adjudication of legislative omissions and the constitution of a universal healthcare system in Brazil. Okay, good. So let's begin. And we begin with, well, constitutionalism. Like, the first thing to bear in mind here is, look, the fundamental thing for constitutional law, for constitutional systems, is a distinction between constitutional politics and ordinary politics, which this picture tries to capture, right? Certain things are within the broader and darker blue sphere. Certain things, constitutional politics, are reserved for the lighter blue. This distinction is fundamental for constitutional law. This is the distinction that I'll be talking about in a lot of ways here. And I'm going to be going back to the same drawing or to variations of it more than once during this talk. Okay. So what can constitutional law do? Well, what constitutional law can do or tries to do many times is to establish some basic agreements on the basis upon which disagreements between political participants should be settled. But there are going to be disagreements on the meaning of these basic agreements. So we need basic agreements on how to settle disagreements about our very basic agreements. I'm going to say the same thing and with examples. It's going to become a little bit simpler, okay? So the first fundamental question for any regime, to any political regime, is who gets to govern, right? And a simplified version of choices or historical things that have happened in systems all over the world is, well, a dictatorship basically works in this way. Whoever controls the armed forces governs, and governs for as long as they have control of the armed forces, right? Well, this is not a very nice way to live. Democracy is, an achievement that is hard to achieve and hard to maintain. But it can also be described in a very simple way, right? The move is from that system, a system of, basically of basic power, to a system in which, whoever has won the last election governs until the next election. Now, this sounds simple, but as I said, it's very hard to do, very hard to maintain. But this is not the same thing as what I was, showing in the previous picture, because in that description, there is no division between ordinary politics and constitutional politics, right? So when constitutionalism comes in, the thing is, well, now you're in a different system, a third type of system. Whoever has won the last election governs until the next election, but only within the sphere of ordinary politics, right? This is the big change. Again, just like democracy is hard to achieve and hard to maintain, constitutionalism is also hard to achieve and hard to maintain, because you need to create a distinction between these two spheres, and you need to be able to maintain this distinction. And maintaining this distinction can really, go against a lot of political interests in a community, okay? So the mirror to that distinction, the distinction between ordinary politics and constitutional politics, is the distinction between ordinary law and constitutional law. Good. So again, a simplified example, what I'm trying to say here is, well, after we establish, a rule about who gets to govern, for example, whoever gets 50% plus 1 votes on the election day governs, we need to kind of figure out what can they do. Very often, what they can do is tax and redistribute. And they can tax and redistribute more or less. If the left-wing party has won the election, there's going to be more taxation of the wealthy and more redistribution. If the right-wing party has won the election, you're going to see less redistribution of wealth, less taxation of the wealthy, okay? Well, that says what they can do. That tells us what is within the sphere of ordinary politics. But what do they need to do, right? This is what constitutional politics and constitutional law tries to do. So in a system like this, if you have a division between ordinary politics and constitutional politics, for example, you might have a right that says a constitutional law might establish that you need to respect property rights. Whoever wins the election, whoever is governing, needs to respect property rights. And whoever is governing needs to respect the right to strike. Now, this is important because when the left-wing party wins and starts taxation and redistribution, a lot of people are going to try to claim respect for property rights as a limit on how much you can tax or how much you can redistribute. On the other hand, when the right-wing party wins and it stops and it's taxing less, it's redistributing less, if the workers decide to strike and to demand for more rights, demand for more social distribution, there's a lot of things that the governing party, the right-wing party that is in government right now can do, but it needs to respect the right to strike. Obviously, in reality, things are more complex because, you know, the right to property can clash with the right to strike, because the right to taxation can clash with the right to property, and so forth. So we are going to need a system to resolve those disputes. But this is basically the world in which you have moved once you have moved to a world of that separates and tries to establish a distinction between ordinary politics and constitutional politics. Good. So so far I'm talking about one system, right? Only one system, simplified version of one system. Now we're going to start thinking about comparisons, right? If we're thinking about comparative constitutional law, we need to compare different systems. If we're going to compare different systems, we need to bear a number of things in mind. Number one, as I already said, this distinction between a sphere of ordinary politics and a sphere of constitutional politics does not exist everywhere. It's hard to come by, it's hard to maintain, and it doesn't exist everywhere. When it does exist, it's a hard distinction to maintain. And it is a hard distinction to maintain because there's always going to be conflict about what is inside and what is outside each sphere. And because on one of the sides of this conflict is often going to be whoever currently controls the government and has the support of a political majority. Also, when we compare two systems in which this difference actually exists, they can be significantly different. What is included and what is excluded from the sphere of ordinary politics changes from system to system. The size of the sphere of ordinary politics and the sphere of constitutional politics can be smaller or bigger in different systems. This is what this image tries to represent. The way the legitimacy of the distinction is perceived in each of these systems can be significantly differently. And the authority and autonomy of courts and their function in maintaining this difference can differ from system to system. Okay, so as I said in this first part, what I'm talking about is that the relationship between constitutional rights, which exists within constitutional law, which exists within constitutional regime, right? It constitutes and exists within a system, a constitutional regime. Good. So now, if I'm asking you if there is a relationship between, the political history and what constitutions can do and, what they mean, and I'm going to be following here, drawing basically on some ideas from a recent book. It's a 2019 book by Bruce Ackerman. It's called Revolutionary Constitutions. And it asks this very basic question, right? How constitutions gain their claim to authority? And it is a sociological and historical inquiry into the ways in which elites and the general public may come to believe that their constitution has transformed the sheer exercise of power into the legitimate exercise of authority. So bear in mind, it's a sociological and historical inquiry. And the question is, does the path towards constitutionalism, which is not the same, different systems have followed different paths to establishing that difference, the difference that I'm talking here about, constitutional politics and constitutional law, does the path that was followed in order to establish that distinction matters if we want to understand differences between different systems? Well, the model that Ackerman proposes and that I'm drawing on here is basically, these are ideal types, but it's a distinction between three different types of constitutionalism, three different types of constitutions because they were established through three different paths. First one is revolutionary constitutionalism, right? Revolutionary constitutionalism is when a movement of revolutionary outsiders gains broader public recognition and establishes a new constitutional regime, right? Now, this is very different from insider constitutionalism. Insider constitutionalism is when political insiders are able to maintain their power through strategic concessions and pragmatic adaptation to the demands of popular movements. Finally, elite constructions is when political leaders negotiate the rules of a new political regime, right? And you can see there's a lot of difference here, right? In the first one, you have a movement, and the movement basically establishes the new constitutional order. The second, you still have a movement, but the movement doesn't exactly take over. No, it's able to get concessions and pragmatic adaptation from whoever is governing, also from political elites. But this is still different from elite construction. Elite constructions happen when, you're establishing a new constitutional order. Now, the reason why you're establishing a new constitutional order varies. Maybe there was economic collapse. Maybe there was a defeating war. Maybe whoever was governing lost its legitimacy and is now out of power. For whatever reason, political leaders are negotiating the rules of a new political regime. And this is a fundamental different situation than the other two. Good? Okay, so why does that matter for rights, right? Well, because, if a revolutionary movement establishing a new constitution, some of the rights in that constitution might really be related to some of the core revolutionary ideals. Now, this is not the same situation in which insider constitutionalism, in which, some concessions to popular movements are being translated maybe through amendments, maybe through legislation, but in some way they're being incorporated. And so you might see new rights being incorporated in the constitutional system through these concessions. Finally, in elite constructions, the rights are basically the product of this negotiation, right? To establish a new constitutional orders, different groups need the agreement of the others. And to do so, they negotiate and they concede, right? They might add one right to the Constitution, for example, as I said, the right to property. But in order to do that, they might have to concede and add a right to strike to their Constitution too. So we're going to have both rights in the Constitution, but not because any of them is the product of a revolutionary movement, but because they are the product of a negotiation between different political parties, different groups, different political leaderships that are establishing the new Constitution. So the insight here is, quite straightforward. Not all constitutions have the same origin, and not all rights in the same constitution are the product of the same kind of political process. And this has implications for their social legitimacy and for the role and the legitimacy of different institutions in enforcing them. Okay? Good. So again, we go back to this sphere. As you can see, not only some systems can be different in how big the constitutional politics sphere is in relation to the ordinary politics sphere, and in what is inside the constitutional politics sphere and what is outside it in the ordinary politics sphere, but they can differ also on how did those rights that are inside the constitutional politics sphere got there, and that can matter. Now, I'm going to add the idea of constitutional justice here, the idea of courts, which I haven't really mentioned yet until now, which is basically the center of our second part of this presentation. So the point here is, if you're going to have a distinction between ordinary politics and constitutional politics, you might have a constitutional justice system that is going to be relevant for constitutional governance. Now, some institutions of the system of justice are going to participate in the kind of disputes that I have already been mentioning, right? Disputes about what is inside ordinary politics and what is inside constitutional politics and how to make sense of all of this. But again, what matters here is, as the sphere of constitutional politics varies from system to system, and it can be larger and smaller, also the sphere of constitutional justice can also be larger and smaller. To begin with, if the sphere of constitutional politics is smaller, the sphere of constitutional justice is also smaller. But not only that, not everything that is within the sphere of constitutional politics can be adjudicated. It's going to be solved through a judicial procedure, right? There are issues of authority and autonomy of courts that matter here, but depending basically on the authority of courts, for now is what I'm talking about, you're going to see a system of constitutional justice that can be almost as large as the sphere of constitutional politics or a lot smaller than that, okay? So, since I'm talking about courts, the point here again is this issue of the historical political origin of the constitutional regime and of the specific constitutional rights can have an effect on the role and authority of courts in adjudicating them. That's the idea. So if you're in a system, revolutionary constitutionalism, you are going to have certain rights that are the product of, revolutionary commitment. Now, on the one hand, this can mean a lot in the sense that, those commitments have a lot of perceived legitimacy and authority. They're the product of, a popular movement that, gained acceptance and was able to establish a new order. But that doesn't mean that courts are going to be very successful in adjudicating them, right? Because at least in the very beginning, right after, the new constitutional system has been established, if courts want to be if courts try to be the ones who are saying what the Constitution really means, they might need to, struggle with the actual leaders of the revolution, the people who, were leading the movement that led to the new Constitution, who established the Constitution, and who are now in government, right? That can be a very difficult situation for a court to be in. Now, here, timeline is relevant, right? That this might be very true at the very beginning, the first years or decades of the Constitution, but of course, things change. After 10 years, 20 years, 30 years, the leaders of the movement, they might have retired, they might have passed away. In any case, they are not in the scene anymore, although you have normal, ordinary politicians that are elected and have been elected and who are now, governing. And now courts might have a very interesting role in trying to, be the institution, and they can build legitimacy and authority to be the institution that is going to redeem the revolutionary commitments. And, now they are in a struggle with ordinary politicians, not the kind of political leadership that won a revolution or independence or, dismantled a previous authoritarian regime. Now, in a system of insider constitutionalism, the situation is different, right? Courts have been part of the pragmatic adaptation, and they probably are going to continue just being that, part of the system of pragmatic adaptation. They're not going to claim a higher legitimacy to talk about real commitments, because that's not really how the system works. Finally, in the case of elite constructions, since the Constitution is the product of this negotiated agreement between different between different members, different groups, different political leaders, you are basically in an incomplete contract situation. And courts can have a very important role, and they can actually claim a lot of legitimacy and authority in being the institution that adjudicate incomplete contracts. Right? That's one of the things the courts do in many spheres of life. Now, the problem here is that if on the one hand, they might claim authority to do that job, on the other, the Constitution itself might not be perceived as having that much authority in comparison to the realm of ordinary politics. After all, it was not the product, for example, of a huge revolutionary movement with a lot of support. It was simply the product of negotiations between different political leaders, and now it needs to claim authority in the face of new political leaders who are also just producing new legislation, which is the product of, negotiations. So why would the previous negotiation trump the new negotiation? That can be hard for courts, okay? So that's, the first part of the lecture that I want you guys to keep in mind. Constitutionalism brings something different for the table, and that's what it can bring. But not all constitutional systems are the same, because the historical path and the politics that led to constitutionalization varies from system to system. Okay, now I'm going to talk a little bit about constitutional courts as part of this mechanism of constitutional governance, right? Good. So constitutional rights, constitutional courts, and constitutional governance all exist in a relationship, in relationship to each other. And in here, I'm going to draw on the works of different political scientists and professors who have basically, really done a lot of excellent contribution to the field, talking about courts as part of this machinery of constitutional governance, right? So Alex Stone-Sweet, with his Governing with Judges, really, talks about constitutional politics in Europe. Tom Ginsburg, Judicial Review in New Democracies, talks about constitutional courts in Asian cases. And more recently, in 2019, there's a new book by Daniel Brinks and Abby Blass. It's an excellent book. I recommend to anyone who is interested in the field. It's called The DNA of Constitutional Justice in Latin America. It's particularly relevant for people who are interested in Latin America, of course, who basically draws on the work of Ginsburg and Stone-Sweet and tries to basically organize some of these ideas, and has also some very interesting original insights and original research, empirical research on how this has happened in Latin America. I'm going to be drawing a lot on contributions from Professor Brinks and Blass in the second part. Great. So what Daniel M. brings and Abby Blas tell us? Well, they basically say that they propose and they defend, and I agree with them, what they call the constitutional governance model of judicial empowerment. Their evidence shows that originating coalitions in designing constitutions seek to craft spheres of constitutional justice that will include those issues they feel will be threatened or ignored by the expected ruling coalition. And in this model, the court is indeed an agent, but of the constitutional governing coalition rather than a ruling coalition. I know that this is a mouthful. There's a lot of different concepts here and can be hard to follow. So we're going to break this down. For now, it's important just to pay attention to this. There's an originating coalition, there's a ruling coalition, and there's a constitutional governance coalition, and they're not the same. They're all political coalitions, they all matter when you're establishing a new constitutional order, but they're not the same. So what are they? Okay, so what Brinks and Blas call an originating coalition is basically the set of actors whose agreement is required in order to produce a binding initial pact, either a constitution or a constitutional agreement. So basically, going back to what we have talked already in the first part of this presentation, we're talking about the people who are on the table establishing the new constitutional order, right? They could be the leaders of a revolution, they could be insiders who are basically conceding to demands of outsiders, they could be, just a diverse, inclusive group of political leaders who are establishing a new political regime. So, the reason why they're there and who they are varies, but in all these cases, you do have an originating coalition, the people who need to agree in order to establish this new constitutional order. Now, what is a ruling coalition? Well, the ruling coalition is the set of actors whose agreement is required to produce a public binding decision in ordinary post-constituent politics. In other words, it's the people who won the last election and who get to govern. So it's the coalition who is governing, who is currently governing. So basically, thinking of the difference between the two spheres, the originating coalition is basically trying to set up a difference between a constitutional politics sphere and the ordinary politics sphere, and the ruling coalition is the coalition of people who rules within the ordinary politics sphere. So now the constitutional governance coalition, you can guess, is basically the coalition that has a lot to do with the constitutional politics sphere. So it's the set of actors whose agreement is required to exercise the mechanisms of judicial control and who have access to the court for protection of their substantive interests, which will be questions of access to power and substantive goals, which, as we already discussed, are going to be presented very often in the language of constitutional rights, right? So the Constitutional Governance Coalition is able, is the coalition that basically has control or can influence, the constitutional court, maybe by nominating justice, maybe by removing justice, and is also the coalition that can bring, as members of this coalition can bring cases to the court, for example, among other things, right? So these would be the three coalitions. Well, let's go back to the same quote now that you know what is an originating coalition, what is a ruling coalition, a constitutional governance coalition. Well, Brinks and Blas, their insight is that, very often, and again, this is also something that Tom Ginsburg and Stone Sweet have said before, very often the issues that they feel will be threatened or ignored by the expected ruling coalition are exactly the issues that are going to be constitutionalized, right? Exactly because you're a member of the originating coalition and you're not very sure about who is going to rule, and you're not very confident that the people who are going to rule are going to, to care about the things that you care. They might be some things that you care about, some issues that you care about are going to be threatened, some of them are going to be ignored. You try to constitutionalize those issues. That's what's going on here. It's not the only way things get constitutionalized, but it's a very important way in which, things get into a constitution. And as I said, in a lot of the ways they get in the constitution as rights. Okay, so this, again, the three spheres: ordinary politics, constitutional politics, and constitutional justice. And you can see how each one of the coalitions has a lot to do with how this sphere is set up and how it works after the system has been put into movement, right? Again, politics happens in time. You're going to have time one, the system established, time two, it's a recent system and it's starting to work. time tree, a decade has passed, 2 decades have passed, and you might be in a different situation, right? In all of this, you just need to keep in mind that you have an originating coalition, a ruling coalition, and you might have, a constitutional governance coalition. Good. So now that you understand what each one of those things is, it's very important to understand that the relationship between the originating coalition and the ruling coalition is not always the same. Again, if you look around the world, in comparative constitutional law, now in some systems, basically the people who are on the table, the leaders who are on the table, the originating coalition, basically they expect to also be the ones ruling and governing after the constitution is put into place, right? So they're putting things in the constitution, but they're also expecting to rule. This might have a lot of effects. For example, they might feel more confident and less threatened by whoever is going to rule because they basically figure that it's themselves. Well, a second situation, which is represented in the middle, is when, there's a lot of overlap between people who are in the originating constitution and people who are in the ruling coalition, but there's also, they're not that similar. The overlap is not complete or almost complete. In this case, you have an originating coalition that is inclusive, it's diverse, it's not secure that is going to always win elections, and even if it's confident that it's going to win the next election, you might be worried that it's not going to win the election after that and the election after that, right? So again, this is very much the type of situation, in which the kind of insight the Brinks and Blas are bringing here are very relevant, right? This originating coalition is going to try to constitutionalize things that it feels could be threatened by people who are ruling after it leaves, because it's not confident on who those people are going to be. It's not necessarily going to be the same people. Great? Okay, so a final situation, which is a particularly tense one, is when the people who are in the originating coalition are pretty sure they're going to be in the minority and they're not going to be ruling. They can see what's going on. They can kind of feel which way the wind is blowing, and they pretty much understand that they're not going to be winning majorities in the next elections. So they're going to try to constitutionalize a lot of things to protect those things from ruling coalitions, future ruling coalitions. But as you can see, because the majority that is ruling after the constitutional order was established was not very much representing the originating coalition, they might feel very, they might not feel very good about those kinds of restrictions because, they're not really part in establishing them. They were not on the table in the same way. Okay, so this could be a very big problem for the stability of a constitutional order. Again, for good and bad reasons, right? I'm not saying that the people in the originating coalition are necessarily good or right, and the people who are in the ruling coalition are necessarily bad. Could be go the other way around. Who is more or less correct in terms of the right direction in which the political system should go. No, this is actually why we have elections. What I'm talking here is how you put on a system in place that is going to have these two spheres, a sphere of ordinary politics and a sphere of constitutional politics. And this has a lot to do with this kind of situation that I'm showing here. Okay, so, we are already talked about a bunch of things, and we can start seeing how they relate. In constitutional politics, depending on the history, if you're going to see, you could see, originating coalition constitutionalizing issues that are threatened by the expected ruling coalition, what we just said. Obviously, you could see an alternative situation in which, what they're constitutionalizing is the core commitments of movement leaders who expect to control the ruling coalition. Clearly, what I'm showing here, the difference between, the first line and the second line could be very much similar to the first drawing here and the middle drawing here, right? In one situation, the people who are in the originating constitution are also the people who are going to rule after it. And in this case, the history might be because this is a movement, a large popular movement who was able to win and, establish a new constitutional order. And in the second situation, we're talking about a inclusive, diverse, originating constitution coalition that established a new constitutional system. Good. whatever happens, be it in the first system or the second system, I already talked a little bit about the kind of differences that you could expect in terms of constitutional justice, but in any case, be it in the first or in the second system, constitutional justice is basically going to be, it's a political space that is subject to contestation and control. That's what's going on, that's what's happening in the sphere of constitutional justice. And if we're thinking of constitutional governance, right, now it really matters the relationship between the original coalition and the constitutional governance coalition. So what is at stake here is, as you can imagine, the people who are, in the originating coalition, who are establishing the new constitutional system, they're not simply putting in the constitution the rights and the ideals and the goals that they think are very important. They're also putting in place a system of government. And they might design that system in ways that are more responsive to just simple majorities, or might be more responsive to the need of a support from a diverse and inclusive coalition, right? If you are part of this coalition and you're not sure that you're going to be governing after the next election, you might still have a say in the nomination of constitutional justices, and you might not let that kind of decision to whoever won the next election, right? Again, you can just think of any of your constitutional systems. I'm going to use an example of Brazil. Now, you can see how this is exactly what is happening right now, right? Bolsonaro won the last election, and as long as it is able to maintain some sort of majority in Congress, it's able to do a lot of things in the sphere of ordinary politics. But there are a lot of things that it can't do, right? Because the Constitutional Court is responsive to a larger and more inclusive and more diverse coalition, right? At some point, for example, he might be able to nominate one of the justices for the court, but first of all, he might not be able to nominate whoever he wants because he needs support from the Senate. And even if he does, that's going to be one justice among 11, right? So this is how this happens. This is how the system works. Now, different systems are designed in different ways. You're going to see systems in which the original coalition and the constitutional governance coalition are basically the same. They're very similar. And also, you're going to see systems in which the difference between the ruling coalition and the constitutional governance coalition are more or less significant, right? Okay, so now that we have gotten to this point and we're all on the same page, I find one of the most interesting contributions of Brinks and Blash to this debate is that when we're thinking about constitutional justice and about what constitutional courts can do, very often we only ask the independence question, right? Are courts independent? They actually plot this out in a 2x2. This is why you have 4 boxes here in a 2x2 system in which, it's not simply if courts are independent. What we really need to know is, do they have low autonomy or high autonomy? Do they have broad authority or narrow authority? So I'm going to talk a little bit about each one of these, right? So a court or a constitutional justice system, but I'm just, for simplification, going to talk about a constitutional court. A constitutional court that has low autonomy and narrow authority, basically, there's not much that it can rule on. And to the degree that it can rule on anything, it doesn't have much autonomy from the ruling coalition. So this court is easily a sideline court, right? Constitutional justice in a system that is designed in that way is going to be, largely irrelevant to politics. Now, there's another type of court that has low autonomy too. So since it has low autonomy, also, it doesn't have much autonomy from the ruling coalition, from whoever won the last election and the current majority that is governing right now. So it doesn't have much autonomy, but it does have broad authority. It can rule on a number of things. Well, when you see a court like this, a constitutional justice system like this, you're going to see basically a regime ally court, right? So the court is an ally of the regime. The constitutional justice is basically going to channel majoritarian politics. And you're going to see the system basically reinforcing the regime goals. Okay, so on the second column, now we're talking about constitutional justice systems with high autonomy. Constitutional justice systems that are designed in a way in which the court has, autonomy from the ruling coalition. Great, but again, you're going to see two different creatures right here when you're looking at those types of courts. you can see a court with high autonomy, with narrow authority. Now, it has autonomy to rule certain things, but it can only rule on a very limited number of things, right? Very often, this court is going to be a procedural arbiter court. Constitutional justice is going to be limited to protecting market and political processes, and that's it, right? It's not a major policy player in a lot of the areas. Now, finally, we get to a very specific type of institution, courts or constitutional justice systems that have broad authority and high autonomy. Now, interestingly, very often, this is what people think about when they think of constitutional courts, but this is only one type of court. And as you can imagine, just like the difference between constitutional politics and ordinary politics is pretty hard to maintain, maintaining a system, a constitutional justice with high autonomy, broad authority, is also not that easy to establish, and especially not that easy to maintain, right? Constitutional design and constitutional politics is really going to matter here. But if you are in this situation, you're facing a court that is a major policy player court. Contested versions of thick constitutional justice permeate politics, right? The kind of debate, we are going to see those things, debates about, which way, which policies, what should be done, becoming debates of constitutional politics debates and becoming really constitutional justice debates, right? A lot of the time. This is what we're talking about. Again, not happen everywhere. Great. So those were basically the two parts of the presentation, which basically wanted to put us all on the same page, right? Now, everyone who is listening to this have a pretty good idea of what constitutional courts, can do, of what constitutional law can do, but also that it doesn't happen everywhere. And even when it happens in different systems, those systems can be very different from each other. Their design can be different, their politics can be different, their history can be different, and that really matters. Okay, so on this third part, I'm going to be talking about rights and constitutional design, and I'm going to talk about, how constitutional rights are part of constitutional structures of constitutional systems, right? As I said before, the people who are on the table in the originating constitution, putting some rights in the constitution, establishing certain issues as, part of constitutional politics, they're doing more than that. They're establishing constitutional structures, they're designing constitutional systems, and a lot of these people are pretty savvy, right? These are politicians. They are not naive. They are pretty aware that, just writing something in a document is not really going to make it true. So if they wanted to have any kind of bite, they are thinking of how they can make that happen, right? Sometimes they make wrong choices. Sometimes they cannot do the things that they want to do. They don't have the kind of support, but they are very often very aware of these issues and, very knowledgeable of things that can be done, right? Obviously, as the field develops, as political scientists write on these issues, people who are writing constitutions today know a lot more than people who are writing constitution in the 70s or in the 40s, but still, these people, even if only intuitively, know a lot of things about how to set up a system, often enough. Okay, so in this part, as I said, I'm going to talk about rights and constitutional design, and I'm going to talk about the Brazilian constitution, about the Brazilian constitutional system. And basically what I'm doing here is I'm going to use two examples from Brazil to discuss how constitutional design can matter for rights. And it can matter in very specific ways. Okay, so firstly, I'm going to talk about the adjudication of legislative omissions, right? Okay, so this is a very peculiar thing that is very characteristic of the Brazilian constitutional system. It's very relevant. It really goes to what I was just saying, right? The people who are establishing a new constitution, they're not naive, right? So the people in the originating constitution coalition who are establishing the Brazilian constitution, they really thought about, what instruments did the legal system give them to trigger judicial review in a scenario of legislative silence rather than legislative action. So they were worried not simply that the legislator or the ruling coalition was going to do things that they didn't want, but that they were not going to do certain things that they wanted to see done, and that the Constitution said that needed to be done. Now, this was a topic of explicit debates in the Constitutional Convention of 1987, 1988 in Brazil. And the Brazilian Constitution contains a set of mechanisms that explicitly empower the Supreme Court to exercise constitutional review of congressional inaction, okay? Here I'm quoting two colleagues of mine, Diego Werneck Arguelles and Leandro Moliano Ribeiro, who have written on this before. Leandro is also a professor at FGV and a good friend, okay? So if you're thinking about, institutional tools for adjudication of legislative omission, interesting, the people in this, the Brazilian Constitutional Convention, they set up two different tools. The first one is the Ação Direta de Inconstitucionalidade por Omissão, or ADO, right? This is the abstract judicial review procedure for when the legislative fails through its inaction to pass a law that is required to give concreteness to a constitutional command. Okay, they didn't do only that. They also created the Mandado de Injunção, or MI for short, right? This is a concrete judicial review procedure for when legislative omission is an obstacle for the enjoyment of a constitutional right in a specific situation, right? So this is a situation which the Constitution says that a citizen has a right and the citizen wants to enjoy that right, but to do so, there is a lack. It needs enabling legislation, and the needed enabling legislation has not been passed. So the MI is supposed to allow this person to go to court and say, look, because they didn't pass legislation, my right has not been regulated. Because it hasn't been regulated, I can't enjoy it. I want to enjoy it. Court, please provide me with the right, because the ruling coalition, the legislators basically haven't. Okay, so I'm going to tell you a little bit about the story of how the jurisprudence over this evolved in Brazil. The first thing you need to understand is that, again, because there were a lot of people on the table and they were negotiating the terms of certain rights and what's going to happen and different issues and different goals, in a lot of situations, the Brazilian Constitution basically said that a right existed, but it also said that, the legislators, after the Constitution was enacted, would have to pass enabling legislation. So a very good example of this, and in which we have some interesting case law, is Article 37 of the Constitution. Article 37 of the Constitution says a bunch of things about civil servants, and it says first that civil servants are guaranteed the right of free syndical association, so they can unionize. They have unions. But it also said that the right to strike shall be exercised in the manner and within the limits defined by specific law, right? So it said that civil servants could unionize, it said that civil servants could strike, but it also said that, basically Congress needed to pass a law that regulated the right to strike of civil servants. Now, but as I already told you, the Constitution, the people doing that, they were not naive. They were worried that, Congress might not do that. That's a thorny issue, public servants, civil servants striking. So they also, gave, for this situation and many others, the MI, right? If legislation was not passed, civil servants, no unions, and wanting to strike could go to court and ask for the right. Okay, so how did that evolve? The story here is interesting and can be told in two very different ways. First of all, right after the Constitution was passed, enacted, October 1988, right after that, in the following months of 88 and in 89, people started going to court and asking for the right, asking courts to intervene. At the very beginning, courts mostly said, look, there's no omission yet. The Constitution was just enacted. It has only been some months, give some time to the legislature. Okay, but that didn't last much time because, already in the 90s, some time had passed and no legislation had been enacted. So courts started basically attesting that the omission existed, attesting that the legislature was at fault, that it needed to enact enabling constitution, but it didn't do anything else. It just notified the legislature that it was at fault. Okay, again, a couple of years later, the court started doing something different. It started to give some time for the legislators to do something. So it was not simply saying, no, you are at fault, but it started to say you are at fault, and if you don't enact enabling legislation in 6 months or a year, I'm going to do something about it. I'm going to start, adjudicating these rights to these people. Now, again, time passed, legislators didn't do much. So the case was again in front of the Supreme Court. And what the Supreme Court did was more than simply go and, on a case by case manner, establish the right of specific unions or specific civil servants to strike. He basically looked at the system and said, you know what? We already have a law that regulates the right to strike in the private sector. So let's just say this. Until the legislator passes specific legislation for the civil servants, the right that regulates the private sector applies in all that it makes sense to the civil servants too. And that's it. And so, basically, no law was passed after that, but there's not a space of a lack of, basically a rule that allows the enjoyment of this right anymore. Okay, good. So as I said, you can tell the same story in two very different ways, right? One story is a very, depressing story in terms of if you expect rights to, become a reality, right? Because what we could say is, look, these people not only established the right, but they even established a specific tool giving authority and to courts to do this. And still, it took 20 years. Only in 2007, 19 years later, the courts did something, right? So this is, a sad story. There's a lot of literature on why it took 19 years, specifically, in general, about the story of the Brazilian Constitutional Court, but also specifically in the area of, the right to strike, of this specific right. But still, it took 20 years. So that's a story of basically that tells a story of insuccess, right? But on the other hand, you could say, well, it took 20 years, but it worked, right? And if the tool did not exist and if the right was not in the Constitution, well, maybe that right wouldn't even exist in the system right now, right? It only exists because the Constitution said so, and it's only regulated right now because the Constitution gave this tool to courts, right? So again, this is interesting because sometimes if you look at, what constitutional rights are doing, not all constitutional rights are becoming effective at the same speed. Not all constitutional rights have the same tools to become effective. And even when they do, if you look 1 year or 5 years or 10 years after the Constitution, you might not see much, but 20 years later, you might see something different happening. Why? Again, because the court is part of this constitutional governance coalition and is influenced by this constitutional governance coalition, which has some level of autonomy from the ruling coalition, but not complete one. So this is part of it. So the court is part of the governance of the system, is affecting the enjoyment of rights, but is not necessarily, a yes or no immediate kind of action, right? Now, I'm going to say a couple of things about our universal healthcare system in Brazil. Again, there's a lot of literature about right to health in Brazil, and a lot of this literature focuses on individual or collective action suits, basically, demanding for specific treatments or specific medicines and so forth. And the literature on this is not always positive on the, on the effects of this for the system. But this is not what I'm going to be talking about today, right? I'm going to be talking about the fact that the 1988 Constitution established a universal right to health, and it also put in place a universal health care system, right? So in this, I'm going to be talking about the Brazilian Constitution, but I'm also going to be talking about a specific article by Rudy Rocha, which is also a colleague at FGV. He's an economist in a different department, who wrote a very interesting article that was published in a book that celebrates the 30 years of the Brazilian Constitution. So it was published in 2018. So this book is a very recent book, a very good book, has the specific article that tells us a lot of stuff about, the effects and of our universal healthcare system. Good. So what Rudy Rocha calls attention to is that the 1988 Constitution went beyond than simply establishing a general right. It instituted a healthcare system and established how services ought to be provided and financed by the public sector. That is, it simultaneously established rights and regulated public policies. The translation here is mine, so it's a free translation. Any mistakes are mine. Finally, so I'm going to tell you a little bit of what the Constitution did, right? This is what it did. Let's look at it in a little bit of detail, right? So the Article 196 of the Brazilian Constitution, as you can see, is a very long constitution. It has more than 196 articles. So Article 196 of the Brazilian Constitution established that health is the right and the duty of the national government, and that it shall be guaranteed by social and economic policies aimed at reducing the risk of illness and or other maladies, and by universal and equal access to all activities and services for its promotion, protection, and recovery. So as you can see, very broad, a very general right to health, universal right to health, a duty of the national government to provide for this, right? Well, but the Constitution didn't do simply that, right? Constitution also established Articles 198, that public health activities and services are part of a regionalized and hierarchical network and constitute a unified system organized in accordance with the following directives: decentralization, full service, and community participation. But again, the Constitution didn't do, the Constitutional originating coalition, the constitutional drafters didn't do simply that, right? They also said that this unified health system shall be financed in the terms of Article 195 with funds from the Social Security budget of the Union, states, federal district, and counties, as well as other sources, and that the Union, states, federal district, and counties shall apply annually in public health activities and services a minimum of the funds derived from the application of percentages calculated on. And then there is a list of rules about, the minimum funds that the Union, states, and municipalities need to spend on healthcare. Again, it didn't do simply that. It also established in Article 199 that healthcare is open to the private enterprise, allowing for a private sector to exist along and on the side of the public healthcare service. Okay, good. So we're getting to the end of this, but what I want to tell you is, in regard to this, actually courts do not play that much of a role, at least not, about in the structuring elements of this, right? The 1988 Constitution established designated funds, and right after it, in 1990, the legislature, the Congress, actually passed legislative acts, very important legislative acts, Act 8080 and Act 8142, both from 1990, right? Less than 2 years after the Constitution, that regulates a lot of how that system works. But again, it didn't stop right there, right? In 2000, so 12 years after the Constitution, a constitutional amendment, Constitutional Amendment 29, established certain rules about the minimum amount of expenditures. Again, for states and for municipalities, I'm basically going to talk here about the union, right? About the federal government. The interesting thing here is that the constitutional amendment established the need of a legislative act that was going to regulate this issue. But again, these people are savvy. They know that if they simply say no, that the future legislation is going to regulate it, regulation might not come. And again, courts might not intervene. So what they did, they established interim rules. They established basically what had to happen. They established the need for a legislative act that would regulate it. But they said, until that act is not enacted, those are the rules. There are a bunch of things there. For now, I just want to say, they basically said at first that, if you looked at the year of 1999, you should make it, you should see how much was spent on healthcare by the union. And for the year 2000, it would have to spend that amount plus 5%. And after that, from 2001 on, it would have to basically correct that value according to GDP growth. So what the amendment is doing is basically say that at a minimum, the federal government needs to spend at least as much as it has spent in the past. And as the GDP grows, this expenditure at a minimum needs to grow with it, right? And if the GDP goes down, the expenditures cannot go down. So this was the basic rule. Again, there was finally a legislative act in 2012. It's a complex act. It does a lot of things. And it basically maintained this rule, right? Previous expenditures, whatever is spent in the last year, plus GDP growth is the minimum that the federal government needs to spend on healthcare. Other amendments followed. In 1995, there was a constitutional amendment that changed the system. Now it was going to be 15% of the net current receipts. Those are going to be the minimum expenditures in healthcare. And but no, the amendments from 2015 established a bunch of interim rules for the years 2015 until the year 2020. And following that, there was a constitutional amendment in 2016 that established a general public spending limit. So it maintained, it affected the interim rules, but that's not really important. The important thing is that it established a general public spending for the government in general, but still it maintained the minimum amounts that should be spent in health. Finally, you should know that there is a specific intervention by the Constitutional Court or by the Constitutional Justice System in that system, which is this interim rules from 2015 to 2020. Because of economic crisis, it meant that the government was going to spend less on healthcare than it would by the new rules. So the Constitutional Court suspended the interim rules and basically said that whatever was established by the 86th Amendment of 2015 should start to produce effects immediately. Okay, so all of this, what I'm going to say is, as you can see, it's not simply about a right to health, a general right to health. What you're seeing here is constitutional drafters and originating coalition establishing, trying to establish different spheres of ordinary politics, and constitutional justice. But you also see that even after the system is established, you are going to have a ruling coalition, a majority that has the right to govern in the realm of ordinary politics. But within the realm of constitutional politics, you're going to see very often a larger, more inclusive constitutional coalition, constitutional governance coalition, and the court, depending on the level of autonomy and authority that it has, is going to be responsive to this coalition in what it does, right? So in the specific case of healthcare, universal healthcare system in Brazil, this is a success story. It's considered one of the most inclusive, most significant inclusive systems that we have ever produced in terms of, general effect in the population. After 1988, life expectancy in Brazil went up 10 years, infant mortality went down 70%, and public health expenditure went up 96%. But here, it's very relevant that not simply public health expenditure went up 96%, but that when you break this down between the different levels, the federal expenditure only went up 32%, but state level expenditures went up 179%, and municipal expenditures went up to 158%. Okay, now, obviously, I don't have a counterfactual here. I cannot tell you that, we have a better healthcare system because we have a constitutional right to health. What I'm telling you is that because the Constitution has constitutionalized these issues, it is a broader coalition that takes part when it's deciding, for example, what is the minimum amount that needs to be spent in this area. Now, again, you should also be aware that this is not simply a rosy picture. The future reserves complex tensions. For example, in a context of dispute for resources, how can you justify the preoccupation with fairness being relatively more relevant regarding health than other dimensions like education and basic income, for example, right? So again, because these are all areas that need resources, the fact that you're reserving a minimum amount to health might be great for health, but this might have larger impacts. These impacts can be positive or not. This is a matter for being relatively positive, definitely positive for the area of health, but you should be aware that this is, there are complex tensions in the future. Finally, what I'm saying here, again, following Brinks and Blass, drawing on their work, is that to the degree that courts intervene here, these interventions are not always in defiance of powerful political actors. They're often very consequential for the politics and policies of a country. The thing is, we are not in the world anymore of simply having, ordinary politics, one sphere of ordinary politics. We are in a more complex world of ordinary politics and constitutional justice is basically part of this machinery of governance. And constitutional rights are, part of how the system is designed, but they're not the whole story. Finally, and with this, I am ending my presentation. I just wanted to say, constitutional law can matter very differently depending on the context, depending basically on the political history that is behind the way the constitutional system was set up to begin with. Also, constitutional courts can matter very differently depending on context, but depending on the political context, the political reality, the political powers that exist within a country, but also the way the political system was designed, giving more or less power to certain veto players or others. Finally, design matters. Constitutional rights can matter very differently depending on how the system is designed in terms of providing for tools for them to be made effective by courts that can be have more or less authority and can have more or less autonomy. In any case, constitutional law can matter differently, constitutional courts can matter differently, constitutional rights can matter differently, but they can matter, and they often do in some way. Now, that's not to say that because every system is like a snowflake, so complex, comparisons cannot be made. Not at all. I mean, if I thought that, I wouldn't be doing comparative constitutional law. Now, comparisons can be made, but when we're doing comparisons and we're trying to understand how different systems work and why they work in that ways and why certain rights are more effective in certain systems than in other, all of this can be very significant, and we should pay a lot of attention to all of this. Thank you very much. And I would love to go to answer any questions or comments and get any comments that you have. Thank you.
Thank you, Tomas. Thank you very much again for accepting our invitation to join us in this program. I would like to remind all the attendants that you can send your questions and comments through Slido. There is a link in the description of this webinar. And I would gladly give word to Professor Adam Chilton, who gave us the first lecture on the theme, to make previous comments and on this brilliant participation of Tomas, that I thank you very much again. Always very nice to hear you talking. So please, Professor Adam, and we wait for the following questions that will be read from Mrs. Thais. Thank you very much again.
Thank you, and thanks, Tomas, for the great lecture. I learned a lot in it. Specifically, I found the examples on the right to strike and the right to healthcare from Brazil, and the way that the Constitution, the courts, the political process all shaped the way that those have been realized in Brazil. Incredibly interesting, and I didn't know about those. One thought that I had as a comment or question to raise is how many of these constitutional outcomes can we predict ex ante versus only categorize ex post? And here's what I mean by this. I thought that the framework that you shared, the 2x2 from Brinks and Blass, was great, and it did a great job of highlighting these 4 different potential types of constitutional courts, where you have the regime court, the major policy player, the sidelined court, or the narrow application court, is a good way to think about the courts. But if you were a constitutional designer and you were setting out to draft a new constitution, and you decided that you wanted to have a major policy player as your court, what specifically would you write down in the Constitution? Would you, for instance, say that you have life tenure or short terms? Would you have a small number of justices or a large number of justices? Would it only have federal jurisdiction versus state jurisdiction, et cetera? And what I often think is, it's not clear to me we know the answer to that. That is, what the constitutional formula the day you're writing the Constitution is to guarantee one of these 4 different types of courts. And in part, one of the reasons I think that we don't know what the constitutional formula is that within a country, these things will change over time. And there'll be instances where there'll be, for whatever reasons, historical circumstances, political reasons, decades where the court is sidelined and doesn't seem to be doing very much. And then other decades where they'll become a major policy player. Or there'll be variance not across time, but across issue areas. For instance, the court might be a big player in the right to healthcare, but not a very big player in the environment or in educational policy or whatever it may be. And what that suggests is that there must be something more than just the written words of the Constitution often going on, because the Constitution might not change over time or across issue areas, yet you still pick up this variance that occurs. And so the result is, I think it certainly is true that there is important constitutional courts and unimportant courts, sideline courts, and major policy players. But it might be something about politics that determines those outcomes and not the written document itself. And that if you were to go advise today, I don't know which country is rewriting their constitution in 2020, but whoever it is, I'm not sure we know what to tell them, depending on which one of these outcomes they wanted. Now, the same thing I think might be true with the constitutional rights themselves. And by that, I mean, if you take the right to healthcare in Brazil, it sounds like that's been a success story. And unfortunately, I don't have a counterexample for you. But I often come across instances where, I've been producing this research saying that on average, many rights don't do very much. And people always have an example from their country or their constitution. They say, this right has been massively important for us. But then there'll be 20 other things in the Constitution that weren't very important and that haven't done a lot or that haven't played a big role in politics. And it's not clear to me, ex ante, we could predict that. Ex post, we can look back and say, for whatever reason, Brazil's done great since 1988 on improving life expectancy, reducing infant mortality. But there's probably other issues that the Constitution tried to address. I don't know what, maybe crime or the environment or something, indigenous rights, where it hasn't done as well. And to me, the point of this comment is to say, I entirely agree that the way to think about these things is to do a job situating the rights and the substantive issues in the broader framework and the structure of the Constitution and of the institutions. And that when the institutions are right, the rights can matter. As the final slide, I think it did a great job summing that up. They can matter differently, but they can matter. But I wonder how we can, make progress on predicting instead of just retroactively describing when this occurs. Anyway, thank you a lot for the comments, Tomas. I thought they were great, the lecture.
Thank you. Oh, thank you so much. Thank you for the comments. Thank you also for your lecture. I watched your lecture. She was excellent, and the book is great. I'm sure it's going to be, hugely influential. Okay, good. So I'm trying to do this quickly, but yes, you're right. What can you predict, right? The thing is, it's very hard to predict what a court is going to do, right? A lot of the times what we're talking about here, and also, I'm not putting words in the mouth of Brinks and Blass. No, they're talking about the structures, the design. There's a correlation between what is designed and the history of how the system was put in place. That doesn't mean necessarily that the system is going to work exactly in that way, right? But there is a difference, right? If the system is not even in place, if the structure is not in place, you might predict that the court's not going to do anything because it can't. Now, there are a lot of situations in which the system is put into place, the structure is put in place, and still the court doesn't do anything, right? So maybe it doesn't do anything for any area of the law, maybe it doesn't do anything for certain rights, it does for others. So these are two different types of questions, right? In regard to why it does for certain rights and not for others, again, some explanation can be contextual. Certain rights might really have more legitimacy, more social legitimacy, but I'm not saying that is that. There's a lot of literature that was probably, and I agree with that, is probably going to tell you a lot about how social movements matter, how, NGOs and the cases that are being brought and what is going on the ground might explain why, you see movement in one area and not in the other. And I would, I imagine that because courts can do everything at the same time, maybe first movers have an advantage, right? Maybe if the courts start acting a lot in the area of healthcare, it's not going to get into education at the same time, right? And vice versa, right? So there's a lot of things that could be explained to you why that's happening in one area or the other. Now, but in regard to the constitutional governance system itself, right, one of the interesting things is you're completely right. You cannot perfectly predict because politics is going to happen. New elections are going to happen. Now, there are two very different things that could happen. They're both very relevant, right? So imagine that a minority player in the Constitutional Convention really doesn't want simple majorities, determining who goes to the court. So there's a supermajority rule at place for nominating justice to the Supreme Court. Great. So the supermajority rule is going to give power to whoever has 20% of the vote in the Senate, for example. Beyond, that group might be a veto player there, 20%. Excellent. Now, you might expect that this is the minimum of power they're going to have, right? You might think that, maybe you're going to be very powerful, and at times your coalition is going to be, above 50%, but at a minimum, you're going to be 20%. Obviously, this could happen, and you're going to see that player playing exactly that role in the future. But, politics changes. And maybe the specific group that is using that veto power is not the same group that put it in power, right? So you could imagine that a socialist party was on the table, putting those, designing that constitution. But, 20 years later, the Socialist Party is irrelevant, but you have the Green Party, and the Green Party is the one who is actually taking advantage of that. So, the people who are inside, specifically the Constitutional Governance Coalition, change, but, you still have a different type of system than if you have, a constitutional governance that's basically majoritarian. So that's one thing. The second thing, and a huge election wave can come, and actually the majority has 75% of the vote and doesn't need anyone anymore, right? So in that situation, you're not even seeing, it's not that, it's not the socialists and now it's the Greens. Actually, no one has the power to do that for that moment. But again, elections come and go. This majority could be losing in the future, and so, right? So this is very relevant for all that, for all of this. This could tell you why courts can do something. Doesn't necessarily tell you what they are going to do. Also, the timeline here is very relevant, and this is part of the story in Brazil, right? The courts are, and here is interesting because now you need basically a judicial behavior model to kind of think about these things. And, judicial behavior models, as you said, are hard. They not always predict very well. So sometimes they can explain better than they can predict, right? But to the degree that, they can explain, the different models might be looking at different things. So if you are following an attitudinal model, if you think that, these judges are acting according to their sincere beliefs, maybe the rules for the people who nominate them are very important. And in time, they're going to still be responsive to whoever nominated them, not because they depend on them. Those people might not have the same amount of power that they use, but because they truly share the same beliefs, right? Now, the strategic model might tell you that no, right? This is not what's going on. They're looking at whoever has the power now. They might be very worried about court curbing and all those types of things. So they're going to be responsive to those kinds of incentives. In the real world, both of those things matter. And this is why it's very hard for us to predict what judges are actually going to do. But still, a court with larger autonomy and larger authority is going to be able to do more, probably, than a court with no authority, no autonomy. And again, often we do see I always find it very interesting, the high autonomy, low authority court. The court that has autonomy to decide against the ruling coalition, but only on very specific issues, because it's exactly the type of court that you see in situations of credible commitment, right? The majority is setting the system. The majority is also ruling after the system, but the majority might need to make a credible commitment to someone. Maybe it's to international organizations, maybe it's to investors, and it's going to set that in place. Again, this might explain you why they're doing this. Obviously, 10 years later, a court might rule against them and they simply dismiss it because they can. You can really predict what they're going to do. This is why all these theories, you need a theory of constitutional design that explains why the system was put in place. But for example, we're going to need a theory of constitutional compliance to explain why the actual players that are governing later on are still obeying those rules, right? There's a lot of game theory and rational choice theory that could go into place here. And again, those are not always rational actors, but still. So that's just say, yeah, I mean, I really think in regard to your research, I was really look forward to see, how your model that looks, for example, at the power of constitutional review and independence, how that model could be made richer by adding those dimensions of authority and autonomy, maybe we're going to be seeing things, maybe that would make that a more precise tool. And I look very much forward to reading an article of you that actually does that. I think there are great things to be seen if those things are combined.
Well, thank you, Thomas. Thank you, Adam, for the question, and Thomas for the comments. I think we have a few questions from the audience, and we still have 8 minutes, so I think it's possible to answer a couple of them. Please, Thais, could you please send the questions and read it to Professor Thomas? Thank you. Thank you again.
Good afternoon, everyone. Good afternoon, professors. So our first question is from Rafael. He asks, how constitutional rights could stop authoritarianism when charismatic leaders base their politics on massive disinformation? And he gives as an example the environmental crisis in Brazil and also the accusations on MP researchers.
Great, that's a very big problem. We're not going to solve it in a couple of minutes, but what I was going to say is that, the research, Professor Chilton's research also addresses this in a very interesting way. What we're talking about here is the problem of, how do you know that the Constitution was violated, right? Who do you trust, right? Normally, right, the fact that you have a constitutional court ruling on the issue should give confidence to the people that are living in the system that happened. But of course, right, if you're dealing with fake news and you're dealing with policies and campaigns of disinformation, that might really not move people very much, right? But what I wanted to emphasize is this. That's a very important problem, but that's only even going to be a problem if you have a context in which two other things exist. First, people need to care that the Constitution was violated, right? Again, Professor Chilton research on Turkey and the surveys that he put in place show that people didn't really care all that much, right? So if people don't really care, the problem is not really disinformation. The problem is the lack of authority and legitimacy of the constitutional order, of the constitutional politics sphere to credibly and legitimately constrain ordinary politics. That's what you're seeing there. It's a very big problem. Again, as I said from the very beginning, establishing the sphere is very hard, and maintaining the difference between these two spheres are also very hard. So what can help? Well, again, constitutional law is not magic, right? It's a law doesn't work simply because it's written on a piece of paper, because someone says, you need to do this because it's written here. You need institutions, and you might need, a political coalition. This is why I was stressing how it's important to think of these issues as, you have a ruling coalition and you have a constitutional governance coalition. So to the degree that, the people who are governing, so this populist, authoritarian kind of leader who is in place and is trying to do a lot of things, if to the degree that you have other players in the system who are also very powerful, who are powerful enough, not to rule, not to govern at that moment, but at least to veto what they can do, that can really matters. And we're seeing that in Brazil right now, right, to some degree. That's what you're seeing, right? So when the current government tries to do something and, the Speaker of the House doesn't go along with it, or the President of the Senate doesn't go along with it, or the Constitutional Justice doesn't go along with it, what you're seeing is that someone who has, kind of a ruling coalition, although barely, but still, who is, has the reins of the executive right now, but really they cannot control the sphere of constitutional amendments. Now, if he had enough of a majority to start amending the Constitution and to start nominating justices the way he wanted, we're going to see a different system in place. In this, again, I totally agree with Professor Chilton in saying the maximum that constitutional law can do is work as a speed bump, right? It can make certain, backsliding slower a lot of the time. But again, not because it's magic, but because it allows veto players to, do something for the moment. In the end of the day, and this is what everyone should know and be aware of, if political leaders win enough elections for a long enough time and have enough majorities, they are eventually going to be able to do what they want, for good or for bad, right? If you support a political leader, you're going to be very happy that it's doing that he or she is doing that, and you're going to actually say, well, it took too long. Why couldn't it happen faster? Right? If you don't, you're going to be very worried, and you're going to be complaining that it happened at all. But again, this is a democratic system. There's a different type of democratic system when you have, a constitution, a separation between a constitutional politics sphere and a, ordinary politics sphere, but still a democratic system. And in the end of the day, if you completely disagree with what is going on, you need to convince voters, you need to vote, and you need to, play a significant role in your political system, right? Complaining about it and complaining about fake news is not going to, change anything on the ground.
I think that answer was great. I agree with every part of that, and think that the right thing to think is that the Constitution isn't magic. And if there aren't people that care in the public and ways to translate those concerns into policy, or at least vetoes or checks on the regime, nothing will happen. And with enough time that the dictators or the autocratic regimes are going to wear down the institutions that check them. And that's, I think, the kind of story that we see in Turkey or Russia or Hungary or Poland, where you give an autocratic leader with an autocratic political party enough time, the Constitution can't stop you if they're concerned enough. So I think what matters is not just what's in the Constitution, but pushing back before you get to the state where the regime is completely taking over civil society, institutions, opposition, etc. But that was a great answer.
So I think if the professor doesn't want to comment anymore, I think we have our second and last question from Eduardo. He says, is the constitutionalization of international law feasible, contrary to the view objecting the analytic value of constitutionalism as an academic approach?
Well, I mean, I'm not really exactly that sure what is the question. I mean, but to the degree that I understand the question, what I was going to say is, if what you mean is if international law can become an autonomous system of analogous to constitutional law, right? Have the same level of authority and autonomy and be able to constrain politics in a similar way. Well, what I can tell you is it's very hard for you to do that without a citizenry, right? The problem here is, the further and further apart the rules are from the citizens, it's harder for people to accept the legitimacy of that system to be limiting their discrete political choices in the specific communities where they live, right? This is a general issue that is as old as constitutional law itself, right? When the United States decided to establish a constitution, they were looking around the world, and what they're saying is we don't have large republics. It's very hard to establish a large republic. Now, federalism helped them in do that, right? So you could say, to the degree the international system can mimic a federal system, you could have a world or a continental type of federal system. Well, yeah, that can be effective in some ways. We have seen that having some effectiveness recently in the EU. But again, you also see the English leaving and Brexit exactly because they don't feel represented. They don't feel like they want to be following rules that are set by powers that are no distance from them. So if I believe that to the degree that international law can really affect systems, very often it's going to be through their internationalization through the political system, right? So it's going to be through the legislators are going to be enacting laws that internalize treaties. You're going to see constitutional courts applying those rules. So to that degree, you can see international law doing a lot of things in the world. But the idea that you're going to have a world constitutional federation, I'm very skeptical about that, and I don't even know if I would be that supportive of it, because again, you are going to be playing a very small role, and your vote is going to really matter very little, maybe when it's diluted among billions of citizens. It already doesn't matter that much, can matter a lot less when it's diluted between 200 or 300 million or 1.4 billion in certain countries, right? If you are making this larger and larger pool, this can be a problem for how representative your democratic system is.
Well, Adam, would you like to, I don't know if you would like to comment on that too? Please feel free.
Sure. Just briefly, I think that often people will hope that international law can be this exogenous source of liberalism that can save us from our own governments when we're concerned that our government is doing something we disagree with. But unfortunately, the same problems that make it difficult for the Constitution to constrain those governments are even more difficult for international law. And so the best hope is, as Tomas said, that if the international laws, norms, treaties, et cetera, can be transmitted through the domestic political process in some way to change legislation, norms, constitutions, statutes, then it might be able to have an effect. But it's very difficult to hope that if you're upset with your government, that international law will save you from that government. I share the skepticism and also concern that Tomas expressed about that. I'll stop there.
Well, I would like to thank again Adam, thank again Professor Tomas. Would like to thank Maria Lucia and all the staff, all the administrative staff that works behind the scenes to make these lectures possible, this forum possible. It's a great effort and a great honor to develop a project like this. And I would like to invite you all for next week. We have a third week on our forum that we are going to talk about corporate and securities law and economics. We are going to have Professor Todd Henderson from the Chicago University Law School and Professora Mariana Pargendler from FGV Direito São Paulo. And offshore, it's a promise of another great set of lectures. And we are all very pleased to have you here again. Tomas, Adam, Maria Lucia, thank you, Thais, for the support and help with the questions. And I hope everyone enjoyed and have a nice evening. Thank you very much again.